Okie dokie. Well, thank you everyone for coming. This is our 8th annual Evil Twins debate. Obviously, I was wrong at the first annual one telling Jim that this was the stupidest idea ever. It's not. And it's proven out. It's a great event. And it's brought to you by the Intellectual Property Institute and the University of Richmond School of Law. It's founded upon the notion that you can have kind of experts in an intellectual property area that have their differences, maybe even are at loggerheads on important IP issues, but they can actually be friendly people in the process of discussing those differences. And so what we've been doing over the years is bringing together great scholars to talk about important intellectual property issues that they disagree on, but airing the disagreements in a friendly exchange, a very accessible exchange, and it's turned out to work incredibly well over the years. So what's our 8th annual topic? Our debate topic today is IP at the Supreme Court, guidance or garbage. You get a sense of the tone already here. As we'll hear in a moment in more detail, the Supreme Court has been incredibly active in the intellectual property area. I think about a decade ago or even less, you might see on one hand how many IP cases you would see in a year. Now I need 2, right, or even I might get into double digits. And so given this high number of cases and the activity in the area, it's only right to kind of ask the question, what is this doing, right? Is it providing us adequate guidance for lower courts, practitioners, society at large, or perhaps it's giving us some garbage? So our evil twins today, we've got Professor John Golden from the University of Texas School of Law. We have Professor Tim Holbrook from Emory. To get this off, and I think this is, it's great, it's fun, on a lighthearted note, we have asked each of the evil twins to write the other's biography. So I'm going to introduce them, but introduce them as their evil twin describes them. Okay, so here's Tim's bio of John. John Golden is the Loomer Family Professor of Law at the University of Texas School of Law. Being a little indecisive, he earned an AB from Harvard in both physics and history. But what about physics of history or history of physics? I guess maybe they didn't offer those. Always wanted to stretch his wings and venture forthward, he decided to get his PhD at Harvard. Fortunately, John avoided creating a singularity during his studies that would have consumed the entire planet. That's why you're still here, which is nice. But realizing that chasing sparks was not for him, he decided to pursue his law degree. Having spent so much time in Cambridge and realizing and wanting to expand his horizons, he earned his JD at, you guessed it, Harvard. And this spring, he will be away from Austin, Texas, from the University of Texas at Austin, to see what befalls him as he's a visiting professor of law at, you get the theme here, yep, you guessed it, Harvard. After law school at, yes, Harvard, he decided to pursue clerkships using a unique application strategy, applying only to judges whose names are associated with food products. This is a very interesting theory. His method was successful. That's even more important about this, that you were actually able to do this. He clerked for the Honorable Michael Boudin of the U.S. Court of Appeals for the First Circuit and Justice Stephen Breyer, very tasty ice cream, of the U.S. Supreme Court. Before entering the academy, John worked at William Cutler Pickering and Hale, now known as Wilmer Hale. I wonder who Cutler and Pickering ticked off. Maybe because they didn't go to Harvard. Okay, so here is John's bio of Tim. After obtaining an undergraduate degree in chemical engineering from North Carolina State, Tim Holbrook decided not to pursue a legal education. Instead of pursuing a legal education, Tim Holbrook pursued and obtained a degree from Yale Law School. An unexpected benefit of Tim's 3 years without legal education is that when he left Yale Law School, he still had great curiosity about the law. Having heard in a New Haven pizza parlor that there were these things called courts, staffed by persons called judges who issued documents commonly referred to as opinions or decisions, Tim, like many graduates of Yale Law School, concluded that he might find some field work to get a sense of what these courts and judges were all about. So Tim decided to clerk for about a year and a half with the Honorable Glenn Archer of the United States Court of Appeals for the Federal Circuit. As has apparently been the case with much that has gone on at the Federal Circuit, something went terribly wrong with Tim during his clerkship. After the clerkship, this graduate of Yale Law School ended up, quite embarrassingly, practicing law. Fortunately, the wilderness years of legal practice were brief. I like that. Within 2 years, Tim was back on track, having obtained a visiting professorship at Chicago Kent College of Law, where he was added to the permanent faculty a year later. By 2008, Professor Holbrook had become co-author of a leading case book on patent litigation and strategy. Since the book's original publication in 1999, it has been so successful in educating would-be patent litigators that the troll-ridden world of U.S. patent litigation is now widely ridiculed as entirely out of control and a substantial drag on our nation economy. It's a good accomplishment, Tim, actually. It's pretty impressed by the real-world impacts of Professor Holbrook's scholarship. The Emory University School of Law hired him to join the faculty in 2009, but Emory soon found that Professor Holbrook could not wreak sufficient havoc as a mere professor. Consequently, he was promoted to be Associate Dean of Faculty. As Associate Dean for more than 2 years running, Dean Holbrook has absorbed so many faculty barbs and insults that by now he is undoubtedly either the purest evil or fully immune to evil individual. In either event, he can be expected to be the most formidable foe in this evil twin debate. Okay, so there we have it. We know our evil twins well now. This is what we're going to do. So John's going to start things off. He will introduce the topic a little bit here, and then present his arguments for a total of about 15 to 17 minutes. We're very precise here. Tim will then get 15 minutes to present his argument. John will have a couple minutes for rebuttal, and then we'll have some question and answers. So, no further ado, our first evil twin, John Gold.
All right, so thanks, Chris, for the great introduction. I was a little worried when you were talking about this as something that brought great scholars here. So I hope you'll get back on track next year, putting Tim aside. But in any event, it's wonderful to be out here. This is my first time at the School of Law at University of Richmond campus. I took a jog around here today. It really is a beautiful campus you have here, and it's great to see my other colleagues in the IP community like Kristen and Jim and Chris, as well as Tim. So, IP at the Supreme Court, guidance or garbage. Chris has already given you an idea why we're talking about this. I think he's essentially on point. And as someone who mainly concentrates on patent law, of course the real answer why we're talking about IP at the Supreme Court is because of patent law. And in particular, I'm not sure the clicker is working. Oh, there we go. The increase in the Supreme Court's review of cases in this area over the last 30 years. The Court has heard lots of important cases in copyright and trademark as well, at least if you think those areas of soft IP can be important at all. But my guess is this discussion is mainly, at least before the Q&A, largely going to focus on patent law. And there is something distinctive, I think, really about what has been going on in patent law. Partly it has to do with the history in this area with the creation of the Federal Circuit in the early 1980s. The Federal Circuit, as many of you may know, was created as a centralized court of appeals that would have national jurisdiction in patent law cases. As a consequence of this, you don't have anymore the primary reason that the Supreme Court generally has for taking cases and deciding them on the merits. As you may know, this court gets several thousand petitions for review each year. They tend to only take about 70 or so of those cases to oral argument and decide them on the merits. The prime driver of grant certs, or at least one seen as the major factor for grant certs, is when there's a split among regional circuits, so that courts in California or in the West Coast have interpreted the law differently from, say, courts in the Northeast or in the Midwest. And then there's a sense we need the Supreme Court to intervene to bring uniformity. Well, we don't have that in patent law, and after the creation of the Federal Circuit, as you can see on this slide showing numbers of cases, patent cases decided on the merits by the Supreme Court since the early 1980s, for about a decade the Supreme Court was largely leaving the field. They were hearing and deciding some patent cases, but these are coded purple in the graph, and that means they were cases involving what I characterize as procedural, jurisdictional, or inter-regime questions, cases lying at the intersection of multiple legal regimes, like the Hatch-Waxman provisions in the Patent Act, which involve an intersection between patent law and food and drug regulation. So the court wasn't hearing and deciding core substantive issues of patent law. But this has changed. This has changed significantly over the past 2 decades. Warner-Jenkinson is the first real substantive patent law case the court hears in the mid-1990s. In there they decide, first of all, that the doctrine of equivalence, a doctrine regulating the extent to which you can go beyond the scope of your literal patent claims, that doctrine is still viable, but it's restricted in certain ways by prosecution, another doctrine called prosecution history estoppel. I can see those who aren't patent experts are, getting really excited to learn more about patent law as I'm citing this terminology here. In any event, what you can see over the last 5 years is that the court has now gone into a mode where it's really quite regularly hearing multiple patent cases and multiple substantive patent cases. It's affected the law on the availability of injunctions. It's affected the law on the types of subject matter, the types of things that can be patented, such as genetic sequences or software-related innovation. This is causing many patent practitioners to want to tear their hair out. It's causing lower court judges and members of the Federal Circuit to wonder how they are supposed to move forward. So there's a real question here. Are we getting primarily guidance or garbage from the Supreme Court? Okay, well, I'm going to move on to I am having trouble with the clickers. This could be part of the evil aspect of this debate. Okay. Or what? Oh, I have to point it. Okay. Okay. Complicated. I'm technically challenged. I was a theoretical physicist, so these sort of experimental things are tough. All right, so I'm now going to make my argument. The argument has a question mark because as my part of the evil twin debate, I was trying to think of what I could do that was nefarious. And then I decided what I could do is really argue both sides of the case, be a schizophrenic twin myself, and then leave Tim in the position of many patent practitioners now looking at the Supreme Court's patent decisions, wondering what he just heard and what he's supposed to do in the wake of it. Okay, so we'll start out, and I'll say, there are lots of reasons to be concerned about the Supreme Court taking these cases. We have a court that is less expert in patent law, in the particular area of law at issue than the Federal Circuit, which hears hundreds of cases in this area each year. And you often see the court struggling to understand, basic aspects of patent law doctrine and the framework of the statutory regime. Further, you have a court that's less expert in dealing with the kind of scientific or technological issues that underlie many of our patent cases. Many of the Federal Circuit judges don't have a technical, scientific, or engineering background by education themselves, but they have had to become more familiar with dealing with this type of subject matter through the cases they regularly face. And so as an example of this, I think we can look at Justice Scalia's concurrence in the Myriad case, which might have the value of being very honest. There, the court, as the court often does when it talks about technological issues, has an account of the science around genetic sequences that reads, I think some people have suggested, sort of like a elementary school or junior high school student's report written after carefully reading the relevant World Book encyclopedia entries in the days when people at least had encyclopedias. I guess you go to Wikipedia or something now. And trying not to reveal the shallowness of their knowledge as they try to get through this report with a passing grade. Scalia says he's going to have none of this. He says, I join the judgment And I join the majority's opinion, which was penned by Justice Thomas in this case, except the portions going into fine details of molecular biology. I am unable to affirm those details on my own knowledge or even my own belief. I'm not sure why he had to throw in the belief part. It actually, what I find a little disconcerting about this is the fact that Justice Scalia can't even bring himself necessarily to believe molecular biology, particularly as these, quote, fine details I often would tend to think are really basics for this field. But in any event, this is, I think, a quite honest opinion by Justice Scalia, and to some degree you could interpret it as a suggestion by the Court that maybe at least some of the members would like not to feel that there's a reason necessarily for them to get involved here, would like to be in a position to give more deference to other players. Okay, so we have ignorance at the Supreme Court. We also have, I think, a limited, or signs often of a limited level of interest. I have to say, at oral argument, the justices do seem quite engaged in these cases generally. And the fact that they've decided to grant them, given that they only grant, say, about 1% of the petitions they get each year, shows significant interest. But there has been some concern that we don't necessarily see the follow-through in the writing and drafting of opinions, the care there that we'd like in order to get proper guidance for the lower courts. And here I have a quote from Donald Chisholm, who for many years has been the leading treatise writer in patent cases, where he says, the justices seem to treat patent cases as second-class citizens and write opinions that read as though dictated while standing for the elevator. Okay, and I think many people who are experts in the area would say this rings true in many ways. I will say, having clerked for perhaps the favorite judge of patent practitioners these days, the author of the Mayo v. Prometheus opinion, which means something to those of you who study this area. It's a very unpopular opinion with the patent bar. Justice Breyer, the elevators at the Supreme Court seem to break down so much that there may actually be more time for writing opinions while standing for the elevator than this quotation suggests. But nonetheless, I think we have seen signs of some sloppiness in the sort of craft of these opinions that further sort of builds on the problem of relative inexpertise in this area. And one opinion I often point to, or have pointed to, is in the eBay case. The eBay case is one where the Supreme Court, in a patent case, announced a new, what it called a traditional test, a traditional four-factor test for permanent injunctions. Said it was a traditional test. There are leading remedy scholars in the United States who say we were never familiar with this test for permanent injunctions. We view this as an innovation in the law. So that's one problem. But there are some basic problems with the craft of how the test was articulated in the court's opinion. It's a four-factor test, but the first two factors are the requirement of a showing of irreparable injury and the requirement of a showing of inadequacy of legal remedies. Well, these are basically redundant. They're really two sides of the same coin. And yet the separate articulation of them without any explanation has led many lower courts to struggle to think, well, what am I supposed to do at prong 2 that I didn't already do under prong 1? Some courts have said these are basically the same and essentially combine the analysis, but others have tried to make, I think, an artificial distinction. A perhaps more egregious error, you might characterize it as a typo, but a perhaps more egregious error was that the past tense was associated with irreparable injury. So the test says that the movement for an injunction needs to show or must show that it has suffered irreparable injury. This makes absolutely no sense because the whole point of the injunction is to prevent, presumably, irreparable injury, not, generally speaking, to compensate for past harm. Nonetheless, lower courts have struggled with this as well, and it shows the problem of just this sloppiness on these, what might be a typo. There's a good point for the law students in the audience about why, when you work on your law journals, you go through all that sort of niggling, checking of language and citations. A small error like this can lead to lots of confusion, and some lower courts have said, well, I guess we've got to prove both past irreparable injury and future prospect of irreparable injury in order to get an injunction now. Okay, so I think we do have some concern about a potential lack of real follow-through. Some believe this is also suggested by the number of unanimous opinions we get when the court is dealing with really difficult issues that have splintered the Federal Circuit. Okay. Now, many argue that there is value in Supreme Court review because the Supreme Court is a generalist court, as opposed to the specialized or semi-specialized Federal Circuit. But I think this is a questionable rationale for the Supreme Court review. The Supreme Court actually has, perhaps in many ways, a more distinctive docket than that of the Federal Circuit. Several decades ago, and I think it's even more true today, the Supreme Court's docket was said to be, the strangest docket of any court, even stranger than that of the House of Lords in Britain, when the House of Lords, with its law lords, was the highest court in that nation. The court is not necessarily great at acting as a generalist court. It's even more distant from many of the concerns of regular judges than the intermediate appellate judges. Fact-bound error correction. If a case is seen only to involve or raise questions of fact-bound error correction, that's a reason for the Supreme Court to deny review. Okay? It means dealing with these difficult factual problems and thinking about how you establish an evidentiary case for certain issues is quite distant from anything the Supreme Court has to deal with. And that's a problem when you have a court trying to articulate tests that are primarily going to be applied by patent examiners, one of several thousand patent examiners in the U.S. Patent Office, or by district court judges. Then Justice Rehnquist in the 1980s had a quip relating to this in a dissent he wrote in a case on the standard for summary judgment, which you might have thought is a sort of general issue of law where the Supreme Court is well within its area of supposed generalist judge expertise. He said the court wrote an opinion there that sounded, quote, much like a treatise about cooking by someone who has never cooked before and has no intention of starting now. Okay, and I think you could probably transfer that language as a description of many patent law cases, given how the Supreme Court often is visiting an issue only once every few decades. Okay. eBay, as I said, is an example here of the limitations of the court as a generalist court. The court in eBay said this four-factor test was the traditional test, said that it was bringing patent law into harmony with the law in other areas. Well, if that's true, why has the eBay test now caused circuit courts in copyright cases, in trademark cases, and other areas of law to feel they have to chuck out their earlier precedents and their earlier frameworks and approaches to deciding on how and when to issue permanent injunctions? There recently was a cert petition before the Supreme Court. It was denied, calling for the Supreme Court to address a circuit split on this very issue created by eBay as to whether eBay was forcing or requiring circuit courts to eliminate presumptions they previously had in relation to the issuance of injunctions. Okay. All right. Well, so you might say, this sort of suggests we're really going to get just lots of garbage from the Supreme Court. We have ignorance, lack of interest or attentiveness, and not much apparent, generalist expertise to provide. So the court is not necessarily going to produce opinions that are right or necessarily going to be expected to be more right, you might think in general, than those of the Federal Circuit. They're not necessarily going to advance clarity, and in fact, many people would say the Supreme Court seems devoted to, mucking things up a bit, eliminating. It's almost a trope that the Supreme Court will take review to strike down a bright-line rule or rigid rule, as they often characterize it, that the Federal Circuit has established. Further, in the subject matter eligibility jurisprudence, the jurisprudence looking to the types of things that might be patentable, so genetic sequences, software-related innovation, the court has shown a tendency to use terms such as inventive concept, which no one seems able to define in a very sensible manner, and which can further confuse or conflate the subject matter eligibility analysis with that under other inquiries in patent law, such as novelty and non-obviousness. Okay. So there are lots of problems. Nonetheless, and here I'm going to make my nefarious turn with 1 minute left, just to maximize the confusion, I actually do believe that the Supreme Court really can provide some helpful guidance in this area of law and can add value. And that comes with the fact that the Supreme Court, in part because it isn't hearing hundreds of cases each year, does come to these cases with a somewhat fresher set of eyes and can, because it's not bound by Federal Circuit precedent, can give the law a kick start when it's fallen into something that's arguably something of a rut, or to put it perhaps more politely, a sort of suboptimal equilibrium or settlement point. Okay? And I think, showing my physics background, so, and I think the court arguably has done that. Yeah, I've criticized the eBay opinion, but I do think that case did add value, and the courts, even the grant of that case, added value by causing practitioners in the Federal Circuit to rethink the degree to which they just started taking it for granted that injunctions were essentially always going to issue once you had a finding of infringement. Okay? So I think that was a positive. Subject matter eligibility. It's a mess. It looks horrendous. Might look very much like garbage. The stench is terrible. Time's up. Please wrap up, I'm told. But I still think there's hope in this area. And I'm a person who tends to believe we need some subject matter eligibility restraints. Under the Federal Circuit precedent, we had moved toward an area where this was devolving into just a practical utility requirement. In a one-size-fits-all system, you have to think about what the all refers to. If the universe of all is too large, that one size is going to start not fitting to a ridiculous degree. So with that, I'll conclude and turn it over to Tim. Thanks.
All right, so I'll take the role of evil twin literally. Oh, got to get these on right? So here we go. There we have it. It's time to be the main evil twin. These are not going to stay on the whole time. They're kind of awkward. But so obviously, I think the Supreme Court's jurisprudence is garbage in this area, particularly with respect to patent law. Now, this is not a new phenomenon. As I'd like to highlight to my students, this has been going on for quite some time. Graver Tank is a case from the 60s where the court, where the court is trying, before the 60s, the court's trying to explain when can something be equivalent in patent law and thus considered infringing. When is it close enough, even when it's slightly different, that you will be liable? And this is the fantastic guidance the Supreme Court gives us. In determining equivalence, things equal to the same thing may not be equal to each other, and by the same token, things for most purposes different may sometimes be equivalent. If that's not the epitome of guidance, I don't know what is, right? So what's interesting about particularly the modern Supreme Court cases is that they think they've always been right, have always been right, and never ever make a mistake. They adamantly refuse to reconsider their own precedents, and when they realize that, in fact, their precedent is inconsistent with each other, they suddenly start saying, what, nothing to see here, move along. Maybe if we just keep reciting these cases and their facts and the holdings, then maybe out will pop something that is actually consistent, when, in fact, everybody reading the decisions knows they are utterly irreconcilable. Right? And so this is part of the problems, the Supreme Court's unwillingness to sort of revisit its own law. You see this, of course, as John mentioned, most extensively in the subject matter ineligibility cases, as I will call them, because only once in all of these cases have they actually said, oh, yeah, you can patent that. So in Bilski v. Kapos, you've got the Federal Circuit trying, and for the first time in decades, well, it existed for decades, actually trying to follow Supreme Court precedent. They realized, oh, we're not the Supreme Court of patent law. There is this higher court. So combing over this utterly inscrutable law of the Supreme Court, they come up with this test that to be patent eligible, your invention has to be incorporated into a machine or transform something in a physical sense. And so this goes to the Supreme Court, and they say, well, that's cute. It's an important and useful clue, but that's not the be-all, end-all of the test. Yet again, here we have some helpful guidance. In disapproving an exclusive machine or transformation test, we by no means foreclose the Federal Circuit's development of other limiting criteria that further the purposes of the Patent Act and are not inconsistent with its text. So in other words, nice try, Federal Circuit, but you keep on trying. But we're not going to tell you anything else about how to actually do this right. And so I think this slide got out of, let me skip to this one. And in fact, Justice Breyer in this context, right, it's my view that in reemphasizing that the machine or transformation test is not necessarily the sole test of patentability, the court intends neither to de-emphasize the test's usefulness nor to suggest that many patentable processes lie beyond its reach. What on earth does that mean, right? I mean, like, so yeah, it's kind of relevant. It's not everything, but it actually may be determinative, and it's just utter gibberish. But they're not done yet, right? In part because of the fiasco that was Bilski, and it's important to note, Bilski's 5-4. Justice Stevens concurs in an opinion that sounds a lot like a majority decision, says that business methods should be categorically excluded from patent protection. And so the word on the street is that Justice Kennedy switches his vote. He ends up authoring the majority decision, which gives us mush. They say, well, there's no categorical exclusion. We don't really know when things are abstract, but this one clearly is. Right? So then they move on to Mayo versus Prometheus, which is also a little bit more of a law of nature idea. And here they tell us if a law of nature is not patentable, then neither is a process reciting a law of nature unless that process has additional features that provide practical assurance that the process is more than a drafting effort designed to monopolize the law of nature itself. So you can't play games, right? We all know that the name of the game in patent law is the claim, that the claim defines the invention, but the court's saying, look, we're not going to let you just sort of write claim language to get around the limitation. But of course, that means that if there are some things that are specific enough to suddenly trigger subject matter eligibility, then it can be eligible. Of course, where's that going to be reflected? It's going to be reflected in the claim, but yet you can't claim around it. So you have to measure it by the claim, but you can't, right? There's this utter inconsistency as to, well, what's the purpose of the claim? And don't worry, it gets worse. All right. So then we get to the Association for Molecular Pathology versus Myriad, the gene patent case that everyone knew they were going to take. In this one, I mean, John showed Justice Scalia's concurrence, right? DNA is really hard, and this is really complex, and we don't want to think about this too much. So what we're going to do is split the baby. And we're going to say that isolated DNA is unpatentable as a product of nature, but C, complementary DNA, is patentable. And why? Because you cut things up in cDNA and you replicate it. We don't really know. Everyone who actually knows things about biological technology says this distinction has no root in actual technology whatsoever. So no, never mind. Look over there. Nothing to see here. But at least, they found something to be patent eligible. For me, that's the biggest takeaway. Oh my word, the Supreme Court actually found technology that they deemed was eligible for patent protection. So I don't even teach Myriad in my basic patent class because there's nothing to teach, right? There's this recitation of preemption is bad. Suddenly we dive into the differences between isolated DNA and cDNA, and out pops an answer that, by gosh, just happens to track what the government had argued, and we move on, right? So it's really no sense of guidance whatsoever. But we're not done yet, right? We then get to Alice Corp versus CLS Bank. This is more along the lines of a business method again. And they now articulate this two-step framework where first you have to analyze whether the invention is directed to ineligible subject matter and ineligible abstract idea, law of nature. And here's what they tell us. Well, in any event, we need not labor to delimit the precise contours of the abstract ideas category in this case. It's so abstract, everybody knows it. except for everybody else who needs to follow this case, particularly when the other claims in this have this very detailed structure about the computer system that is used to actually implement the business method. I'm not entirely sure what's abstract about that. Moreover, remember Bilski, they told us how important machine or transformation could be as an important clue. Yeah, those words don't appear in the decision. Right, so suddenly that useful clue isn't so useful anymore. So we've now shifted away from Bilski. And now what's happening with claims, right? The step 2 in Alice is that you have to ask, is there something else in the claims that somehow transforms the nature of the claim into a patent eligible application? And they talk about this search for an inventive concept. But it's not in the claims, right? This inventive concept idea is divorced from the claims. Similarly, in the Quanta case, which deals with patent exhaustion, first sale, right? Once you buy something, they can't sue you for patent infringement. They also say, well, we're not really worried if you've sold the invention. What we're worried is if you've sold something that contains the essential or inventive features. So now the claim apparently delineates your invention when it does, except when it doesn't. Right, that we've now lost this the touchstone of the claim being the important part, and so the name of the game is no longer the claim, but we have no idea what this inventive concept is. No clue whatsoever. Again, a lot of hand-waving and no guidance. KSR International, the big obviousness test, I keep thinking we waited over 30 years for our first obviousness decision, and this is what we get. Right, the teaching, suggestion, or motivation test is dead, it's alive, what do we know? And again, kind of like in Bilski, it's a helpful insight, but not some sort of requirement that the prior art show you how to combine the things together. You get the return of the doctrine of obvious to try, that something is obvious if it is obvious to try those various permutations, jettisoning the Federal Circuit's precedent, which admittedly had attempted to overturn Supreme Court precedent without bothering to tell them. But when you read KSR, it really becomes this kitchen sink totality of the circumstances analysis, including what motivations might people in the design, what about the market, right? And so it's a technical standard, it's a market-driven standard. It's a little bit, not a little bit, it's a lot of bit amorphous. From this term, you've got Octane Fitness dealing with fee shifting, where they have to define, or I'm sorry, dealing with indefiniteness. And our standard is now that, I'm sorry, I'm confusing myself now. It is dealing with the idea of when you can get fee shifting and when does a case constitute exceptional. And they say basically it's one that stands out from others with respect to the substantive strength of the party's litigating position or the unreasonable manner in which the case was litigated. So exceptional means exceptional. And that's all they say. And they say, well, we'll leave it to case-by-case determinations and we will give absolute discretion to the district courts to figure this out, which means no one can figure it out because every district court can happily decide what they think is exceptional. And the hands of the Federal Circuit are tied because they can only reverse if it's an abuse of discretion. That is the epitome of lack of guidance. Then relatedly, Nautilus, now indefiniteness, right now the Federal Circuit had a very strict standard that a claim was indefinite only if it was insolubly ambiguous and not amenable to claim construction. The Supreme Court articulates that a claim must inform those skilled in the art about the scope of the invention with reasonable certainty. What does this mean? Like, what does reasonableness mean in this context? In a lot of other contexts, we talk about reasonability as an effort to modify behaviors, right? In negligence, there's a duty of care. So we want future parties to behave in certain ways. What are we hoping people will do here? Be more reasonable in drafting their claim? What activity, what modification of behavior are we hoping for? Is it just that we hope you will actually draft claims more clearly? But what does that mean? What's our basis of comparison, particularly since every claim and every patent is going to be unique and idiosyncratic to that patent? So this reasonability analysis doesn't really help us terribly much. Now, in order to have credibility, I have to admit that the Supreme Court doesn't always screw things up, right? On occasion, they get things right. The Medtronic versus Murawski family case from this last term, where they took on the Federal Circuit's presumption shifting, that one was like, yeah, what was the Federal Circuit thinking, right? That clearly was just saying, please reverse me, please reverse me. This has no tie to anything in declaratory judgment law. Some of these other areas as well, I think they at least moved the ball a little bit. Pfaff versus Wells Electronics, giving us a somewhat fairly concrete standard. standard for the application of the on-sale bar. Warner Jenkinson and Festo dealing with prosecution history estoppel, but giving this presumption framework, which is an attempt to try and balance somewhat clearer rules versus allowing context to matter. And so presumptions can often act as a way to balance those tensions, creating default positions and only moving from those default positions when the circumstances are merited by the facts on the ground. Traffics is actually a trademark case, but it's dealing with the line between trademark law and patents. And in essence, they create a kind of presumption that if you've patented the item, then you're not going to get protection under trademark. And so these, I think, aren't terribly bad, although, most of them are also a little bit older. So what's going on here, right? I think clearly the recent cases reflect the Supreme Court shifting to contextual analysis, rebutting and rejecting many of the Federal Circuit's sort of more bright line rules. And in some sense, these shifts may be good, right? Making it easier to fee shift is a way, it can be a good thing in combating patent assertion entities. Same with proving indefiniteness. In fact, if you look at the Supreme Court term from last year, it really is the patent assertion entity patent troll term, where they're clearly aware of this dynamic in the market, and they're taking steps to sort of head off patent assertion entities and head off some potential congressional legislation, which unfortunately is probably coming back. But the question is it worth the cost? Right? We clearly have a huge loss of predictability in these areas of the law. The lower courts have to struggle to figure this stuff out, particularly eligible subject matter, where the Supreme Court keeps intervening. Let the courts catch their breath. Take a moment, pause, right? Will the Supreme Court give them time to do so? And really, is all of this transition worth the expense of the uncertainty that we have in the patent system? Thanks.
I don't even know if there's anything after this slide. Stuck with it. All right, so yeah, as you know, there's some overlaps. Tim is definitely perhaps less enthused about the state of the law than I am. But I think what his points raise the question, what's the alternative to what the Supreme Court is doing? As he suggests, the court has often been moving the law toward consideration of greater context. And if we look at KSR, I think that's actually a successful case, in my view, of Supreme Court intervention. There have been a number of critiques of the patent system, reports developed by institutions like the Federal Trade Commission, the National Research Council for the National Academies of Sciences, which suggested that the standards for patentability had gotten too low. The Supreme Court intervened in KSR, helped nudge us toward a higher standard for patentability with respect to this critical requirement of non-obviousness. They didn't provide a new test, but I think non-obviousness is naturally, essentially, a kind of totality of circumstances analysis. And I think in this context, when you have a court that's relatively an expert, the best thing it can do probably is to provide an illustrative analysis, which I think they did in that case, in Justice Kennedy's opinion, going fairly carefully through the facts. I think, for me, it's perhaps the best Supreme Court opinion in terms of really trying to analyze the facts that I've seen on non-obviousness. And the court has shown restraint in the wake of that. They have let the USPTO and the Federal Circuit and lower courts try to figure out how to work in the wake of this. So that gives me hope in relation to another good point made by Tim, that if the Supreme Court is going to intervene, is going to say, we're trying to move you in this direction, but we're not going to provide the final guidance because, in part, the Supreme Court has sometimes articulated this explicitly, we don't believe we're the experts in the area. The Supreme Court needs to allow the more experts body some time to figure that out. Okay. On another point Tim makes, he says how the Supreme Court has shown unwillingness to revisit their precedents. I actually agree quite wholly with this point. I think I have a forthcoming piece which, as part of its title, says, Fluke said one thing, Deere said another. And this is essentially borrowing language used by Justice Breyer, I believe, at the oral argument for the Mayo case. where at some point he said to counsel, isn't part of the problem here that, we look at our precedents and Fluke says one thing, this is a subject matter eligibility case from the 1970s, and Deere, a subject matter eligibility case from the early 1980s, says another. Okay, so he appreciated the problem, the tension between a lot of the language in these precedents that the Supreme Court cites over and over. But then when he wrote the opinion with a unanimous court that presumably didn't want to really revisit his precedents, he then wrote, as often happens in these cases, sort of papering over, in my view, the differences, which makes it very difficult when you do have language that really is in tension, perhaps an irreconcilable tension. It really makes it difficult for the lower courts and practitioners to figure out how to go forward. So anyway, with that, I do still think there's hope. I actually think KSR is a sign of hope for us and what the Supreme Court can do, but I'll turn it over to you for your questions. Thanks.
When you were talking about the case and how Stevens was blaming the patent slayer and God and Emory, do you see any of the new justices stepping into his shoes as patent slayer?
Well, if you look at Alice, right, Justice Sotomayor joins into the concurrence who embraces Justice Stevens' views that these should be categorically excluded business methods. So I think she may be in that camp. But I don't see anything that suggested that it's going to be quite at the level of Justice Stevens, at least not yet. I think Justice Kagan is sort of still getting her feet under some of these issues. And it was interesting. So everyone assumes the Supreme Court's anti-patent. I'm going to segue off your question a little bit. But I went to the Akamai argument, which neither of us talked about today. But it was interesting in that case, they were actually concerned about making patent protection too low. And the whole conversation was that if you allow, and these cases are the multiple actor infringement cases where multiple parties perform steps of a single method. And they said, well, if we allow this to go on, then don't we really reduce and eviscerate the value of patents? So in that context, they did seem to recognize that the patents are valuable. We're not out to destroy them all. That gave me some pause and some hope that maybe there's a greater respect for patents than perhaps their decisions and the appearance of the court suggests.
Oh, well, I was just, I think that sounds about right. And I think Justice Kagan, it was interesting, I believe, didn't join the Sotomayor concurrence in the Alice case, which, suggests that business methods should be unpatentable, which may be, consistent with Tim's view that she's still looking to think these things through, hasn't come to a settled vision on that. I think there is some truth to that. Of course, you might say then perhaps their strategy should be just generally the sort of LabCorp metabolite strategy. It will grant the case, send the signal that way, and then dig it, dismiss it as improvidently granted. And that case, even though they dug it, dismissed it as improvidently granted, did seem to send this signal to the system because you saw the USPTO and the Federal Circuit moving. That was the build-up to the Bilski case where the Federal Circuit came out with this machine or transformation test. I think partly, triggered by that signal through the dissent from the dismissal in that context. And I think Tim has written about, maybe I'll show that I'm not totally hostile to my evil twin. Tim has written a bit about this in the context of just grants, of cert grants, where you've seen the Federal Circuit responding, like in the build-up to KSR, where the Supreme Court was going to review the teaching suggestion motivation to combine test as the test for obviousness. You saw the Federal Circuit seeming to bend over backwards in opinion over opinion, say, oh, this isn't a rigid test, and you can, it doesn't require explicit documentary evidence of this, teaching to combine. So I think the court has shown an ability to send those signals. As I said, you could think, ironically, that maybe the best way to do this, if you're concerned about what actually hears in their opinions, might be to grant the case, but then dig it, dispose of it without actually issuing an opinion.
Yeah, to some extent I agree, right? And it's a good thing, as John's written, right, to perhaps disrupt some of the ossification in Federal Circuit law if they're not willing to revisit it. But you can do that without these rather broad, sweeping decisions, right? That if you really want to disrupt the law a bit, then make it narrower. And so this is where I differ a little bit with John on KSR and the impact that KSR had. So if it really was just the issue of TSM, then they could have tweaked that far more narrowly and said, look, in essence, this Federal Circuit has created the default of grant if everything is known but you lack the motivation, and we think that default is wrong. And so the absence of the motivation should, in essence, mean that it's obvious. And in essence, you could think about TSM creating presumptions of obviousness, teaching away presumptions of non-obviousness, and if you don't have either, then just stick with Graham, right? There were narrower ways to write that decision that say, look, Federal Circuit, you're a little off base here. And they could still use some broad language in slamming the Federal Circuit, but the doctrinal shifts that they could make could be a bit narrower and a little more pointed. And so I think that's part of the problem. And then particularly with subject matter eligibility, at this point, it's like, stop and let us do something, or give us something. Like, so my great hope in Alice that was not realized was that the method claims go down as an eligible abstract ideas, but the system claims survive, right? So we have some line drawing that we could see, aha, this is enough, this is what it takes to pull you back into eligible subject matter. And we didn't get it. And we got, the whole, and we're not going to talk about abstract idea because this one clearly is, because we said so, right? So that, when they start painting with that broad of a brush, it's problematic.
Well,
I was going to say, there's some differences I see in law, and that you've got the intersection with technology that makes them a bit uncomfortable. I do think there is the structure that we now have with the Federal Circuit, in that the Supreme Court is reviewing what they've called it an expert court. And so they've got to compete with a court that is seemingly expert. And so in my mind, that may explain some of why so many decisions tend to be unanimous in the Supreme Court, aside from maybe we don't care about patent law, and maybe we need to speak with a unified voice because we're competing in some sense with an expert institution. And so if we ourselves are fractured, then that undermines our legitimacy in speaking in this area. If we speak with one voice, that carries far more weight as a legitimacy, sort of expressive dynamic, than if we're fractured. And so I think there is that odd dynamic. I think that they're less concerned about that recently, but you see that sort of odd tap dance in some of the earlier cases, Supreme Court cases.
Yeah, I think it's a good question. I think if you ask people in tax law or securities law, how they feel when the Supreme Court hears or takes a case in their area for review on the merits, they probably feel many of the same shudders that people in patent law feel. There is a sense often when the court takes cases in sort of technical, complex areas, there's a good chance it's going to mess it up in a way that at least those who are expert in the area find very problematic. Now, there are, as Tim said, I think the problems here, there are some structural reasons why the problems here may be worse than they generally are in other areas. One is because of the Federal Circuit. What happens there is you don't get these circuit splits. And what the court says with certain issues over time, another reason to decline to take a case is because we want to let this percolate a bit longer in the regional circuits. And then we'll see. We'll get different circuits addressing this. They'll come to different resolutions, somewhat different tests. We can see how those play out over time. We can see what the trend is in the decisions over time, and that can help provide guidance to the Supreme Court as to the options, how they can work out where the lower courts seem to think the better solution lies. A further thing that's distinctive about patent law, which we didn't talk so much about so far today, is the weakness of the USPTO as an administrative agency. In other technical areas of law, you have an administrative agency that has substantive rulemaking authority into which the courts, including the Supreme Court, well, there's a question whether the Supreme Court actually does give Chevron deference and applies its own doctrine, but to which the courts will tend to give greater deference than they do in this area. And so that's another sort of problem for the courts dealing with technical subject matter. I've argued it's a particular problem with subject matter eligibility, which I view as a kind of categorical decision as to what types of things are patentable that is ill-suited to this case-by-case adjudication process. But I think those structural problems are part of the reason why this area, I think, is perhaps justifiably seen as a little more distinctively problematic than others.
Well, thank you very much.
Great.
So they could really show off that they were an evil twin. Hopefully these will be present, really, really present in their office, or maybe right outside of the associate dean suite here. So for those who, there are COE forms right outside, and then there is food in the commons area. Thank you so much for coming, and thanks, John.
Okay. Thank you. Awesome.